you so much. My name is Nyaga Dominic. I've been an editor at the Platform for Law, Justice and Society this past 5 years. I started working here as a law student at Strathmore Law School when I was formally introduced to Honorable Gitobi Manyara, and eventually my role culminated into part of the editorial process. So these past 5 years, I've been an editor, and we've been doing a lot of work, especially with respect to commentaries and articles, and actually publication of articles, which to a very large extent contribute to current affairs and also a commentary on the jurisprudence that is emanating from Kenyan courts. Of course, this is a bittersweet moment for me because after these years of working here, I'm now proceeding for my master's in law at Harvard Law School, where I'm starting the program this fall. But it's also a very opportune moment to see that you're now going to the next level, which is going digital in terms of video production and commentaries of the articles that we've published coming from our authors. I think this is also a very good opportunity for them, for our authors, to actually take what is on written form to the next level in the sense that our audience can comment directly in terms of either rebutting or critiquing what it is that our others have actually produced. So we look forward to more engagement with our audience. As you know too well, our audience cuts across different areas of specialization and in different domains, including the judiciary, the academia, and also in different law schools. So we look forward to engaging you more. And this morning, as Honorable Gitobi Manyara had mentioned, we have young Green Peter Mudei, a student from Kabarak Law School, who's been contributing severally to the publication. So his article today is going to be a commentary on the presidential immunity. I don't want to delve into what it is about, but he's here and is going to take it from here. So I take this opportunity to welcome young Green so that he can proceed and dissect for us what his article is about. And from there, we'll be inviting commentary on what his article is about and also publishing various views on what our audience thinks about his article. So young Green, welcome.
Okay, so thank you so much for this opportunity. As earlier introduced, I'm young Green Peter Mudei, a law student at Kabarak University, and also graced to be an author with the Platform magazine. Today, I will be presenting on my paper that I did titled Presidential Immunity in Kenya, a critique of the Supreme Court's interpretation of Article 143(2) of the Constitution. In the paper, I argue based on what the Supreme Court said in the BBI case. And I start by looking at the history of presidential immunity in Kenya before coming to look at the interpretation that ought to be given to the Constitution of Kenya 2010. And I look at this also vis-a-vis the rules of interpretation. So first, I look at the drafts, that is the Bomas draft, and the harmonized draft and the revised harmonized draft, and I try to find out what was the desire of Kenyans before the enactment of the Constitution of Kenya 2010. And if you read the CKRC draft, the final one, you'll realize that at page 198, despite the fact that that Kenyans wanted to protect the president from court proceedings, you will realize that they had the desire of ensuring that also the president is not above the law. When the Supreme Court was presented with this matter, they started by explaining the types of immunities that are there. They explained absolute immunity, sovereign immunity, they explained functional immunity. And they proceeded to state that the president is protected from court proceedings, and there is no instant, whether in criminal matters or civil matters, where the president can be taken to court. I did not have a problem with the interpretation of Article 143.1 on criminal matters. But when it comes to Article 143.2, I think the wordings of the constitutions are very clear that the president is protected from civil proceedings only where he performs something that is within the ambits of his office work. So the Supreme Court went around the corner and they stated that if you give purposive interpretation to Article 143.2, then it means that in no instance the president can be taken to court. And they stated that if you want to take the president to court, then you sue the office of the Attorney General. But I posed a question to the judges of the Supreme Court, and the question is, what then will happen if the wife of the president wants to divorce the president and the president has been subjecting the wife to torture? Shall we still go by the purposive interpretation? Then, shall we have to wait for 5 years, and if it is that the president is going to run for the second time for 10 years, for justice to be given to the wife of the president? The second question that I posed unto them is, what will happen if the president infringes the rights of Kenyans? For example, if the president slaps someone, will we have to wait for the president to leave office for us to be able to enforce the constitutional rights of Kenyans? And I went forth and argued that the interpretation that the Supreme Court gave raises the president to be above the law and thus violates the doctrine of the rule of law. The Supreme Court relied in a case when giving their interpretation from the American court, the American Supreme Court in Texas, that is the Nixon case. They did not take into consideration that Kenya and the United States of America have totally different democracies. And they failed to look at the position that the United States of America was in before the Nixon case came into play. Because before the Nixon case, you will realize that in the United States of America, they stated that yes, we cannot take the president to court so as to protect presidential confidence when he is conducting his duties. But they stated that it does not extend to civil matters that are outside the ambit of the presidential office work. And that is the suggestion that I was suggesting for Kenya to pick, and that is what Justice Ibrahim in his dissenting opinion stated. That yes, let us protect the president, let us stop citizens from suing the president in court. But now when it comes to matters that do not require the interpretation of the president of whether they relate to his office work or they do not relate to his office work, that is matters dealing with the constitutional rights of citizens, then let us have the president being sued in his own personal capacity when he is in office. I think that one will not be able to interfere with the presidential confidence in carrying out his duties because the matters are not related to the office work that he is doing. That is the summary of the paper that I did. Thank you.